Start. Learned Counsel for the Respondent Union, on the other hand, has urged that wages were not paid to the employees of the petitioner company since December 2006. The union with which the petitioner company entered into the settlement does not represent the majority of the workmen. The circumstances led to the workmen from the respondent union, the registration of which was challenged in a writ petition. It is contended that in view of the interim order passed by the Supreme Court in a special leave petition staying the operation of the order of the division bench of this court passed in a special appeal, the registration of the respondent union stood revived. It is contended that even an unregistered union is not debarred from representing the interest of workmen in this regard. Learned Counsel has referred to the aforesaid judgment of the division bench of this court in special appeal number 1699 of 2010, in which, while observing that whether the circumstances existing after 7 years of the settlement still justify its terms to be binding on more than 2500 workmen, which is about 80% of the total number of workmen which were employed on the date of lockout, requires to be examined by the industrial tribunal. The court held that it is not disputed that even the workmen of unregistered union may make a reference by raising an industrial dispute. Learned Counsel in this regard has referred to paragraph number 4 of the judgment of the Supreme Court in the matter of Newspaper Limited, Allahabad versus UP State Industrial Tribunal. The Learned Counsel has also urged that the court had further observed that the industrial dispute had been referred suo motu by the state government, and as such, the satisfaction of the state government cannot be lightly interfered with by the High Court, nor the settlement could be said to be binding on the state government for all times to come if it is satisfied that there exists an industrial dispute which needs to be adjudicated and resolved. The court had further observed that the settlement was inconclusive and was entered into to bring temporary industrial peace, and it did not end the relationship of employer and employee. The Learned Counsel has referred to that part of the award which deals with whether the layoff done on 15 to 2007 is correct or legal, to contend that the settlement was never filed on behalf of the petitioner company before the industrial tribunal. It is contended that given the definition of layoff appearing in section 2 of the UP Act, it was incumbent on the petitioner company to have demonstrated before the industrial tribunal that circumstances existed justifying layoff by the petitioner company. That having not been done, it is contended it is not open for the petitioner company to challenge the award. It is further submitted that it is evident from the cross-examination made on behalf of the authorized representative of the petitioner company that no documentary evidence was filed, and neither was there any material placed to demonstrate that 50% of the layoff compensation was paid. In rejoinder, Shri Naveen Sinha, learned senior advocate appearing on behalf of the petitioner company, has contended that way back in the year 2006 itself, the petitioner company had become sick, which finally led to the order of liquidation passed by the NCLT under the code. It is contended that the petitioner was not healthy company where the production was going on in full swing that could enable it to meet its statutory liability. Having heard the Learned Counsel for the parties and perused the record, The issue that arises for consideration is whether the award made by the Industrial Tribunal was justified. For consideration of the issue, the submissions on behalf of the learned counsel require to be analyzed. Annexure number 7 to the writ petition is an order issued on 21/5/2008 passed by the ex officio secretary to the Labour Department of the Government of Uttar Pradesh communicating the opinion of the governor regarding the industrial dispute between the employer and its workmen and referring the same under section 4K of the UP Act suo motu. The aforesaid order of reference was challenged by the petitioner company in a writ petition which came to be dismissed on 17/9/2010. In the special appeal filed by the petitioner company against the aforesaid order, the appellate court upheld the settlement to be binding despite it being unregistered. However, held that the settlement is not binding on all the workmen of the petitioner company. It was held as follows. We find that though learned single judge has committed an error in law in holding that the settlement or agreement to be binding must be registered under section 6B of the Industrial Disputes Act and has ignored the ratio of the judgment as well as the judgment of the Supreme Court in National Engineering Industries Limited versus State of Rajasthan Supra in respect of the validity and effect of the settlement arrived at during the course of conciliation proceedings. He did not commit any mistake on the other count, namely that in the circumstances of the case, the settlement is not binding on all the workmen of the petitioner company. From the facts and documents available on record, we find that the question whether the agreement is valid, fair, and reasonable, and whether at such a distance of time the open-ended provisions in the settlement giving the opinion to the management employer to take some of the employees at its discretion, leaving the remaining employees with only 50% of layoff compensation and which has also not been paid in full or even in part awaiting finalization of draft resettlement plan before BIFR is a question which requires to be considered by the Industrial Tribunal. The reference made by the state government as to whether the layoff was legal and valid, and if it is held to be illegal and invalid, the benefits to which the laid off workmen are entitled is a question which will also require adjudication of the validity of the settlement. The argument that the settlement is binding upon all the workmen does not meet the question raised by Ms. Bushra Mariam that the settlement is not valid in law inasmuch as it is unfair and thus against public policy. In the circumstances, even if the settlement which did not resolve the dispute with all or even majority of workmen and was not conclusive as it provided for only part payment of layoff compensation when it was entered into on 13/4/2007, treated to be binding on all the workmen. The question whether the circumstances existing today after 7 years still justify its terms to be binding on more than 250 workmen, which is about 80% of the total number of workmen which were employed on the date of lockout, requires to be examined by the Industrial Tribunal. In case the settlement is not found to be illegal as it left an unguided discretion to the employer to take back a group of workmen in employment, leaving the majority of workmen to be laid off for an indefinite period, providing payment of only 50% of the laid off compensation, is not found to be legal and valid. its binding effect on all the workmen would not make the settlement valid for all the workmen for denying a